All right, everyone, it's noon. We're going to get started. Good afternoon. Welcome back to CCI Herodia's last Lunch and Learn for 2025. My name is Sonja Hodis. I'm your moderator as well as a condo lawyer. And joining me today are four other condo lawyers. And together we are going to provide you with an update on cases from the CAT and the courts on matters that affect all of us in condo land. And it's an appropriate day to have a discussion about case law because CAT announced this morning that they released their 1,000th case today. So I guess we're celebrating that as well as talking about all the other cases that are happening in condo land. Joining me today are Patricia Elia, Ashley Winberg, Jake Fine, and John Devellis. And I want to just thank all my fellow condo legal beagles for joining me today and sharing their insights on some of the cases from 2025. All of their bios and their contact information will be posted in the chat box during the webinar, thanks to our chat master, Debbie Dale. Thank you, Debbie, for managing that chat box for us and keeping us informed throughout the webinar. Speaking of the chat box, if you are a property manager and you want to record your attendance today, make sure you get your name and company name in the chat box to confirm your attendance. And speaking of thanks, I want to take this opportunity to thank the sponsors for today's webinar. If you've been to any of our webinars, you know that without the generous support of our sponsors, we are not able to offer these webinars free of charge. So thank you to Elia Associates, Condominium Lawyers, Pretium Consulting Engineers, Common Ground Condo Law, and Engineering Link for their support. If you want to find out any information about our sponsors, all you need to do is go to our website, and on the landing page, if you just scroll to the bottom, you'll see their logos. Click on their logos. It'll take you to their websites where you can find out more information about the services they provide. Or you can just go to the event page for today's webinar, and you'll find their logos there as well. And just click on those logos, and it'll take you to their websites. This webinar today is being recorded. So if you miss anything while you hear the speakers talking, you didn't get it down, don't fear. You can watch the webinar at a later date. We'll be posting it in the next 7 to 10 days on our website as well as on our YouTube channel. And if you're watching us on our YouTube channel, make my Christmas wishes come true, and please take a moment to subscribe to show how much you love these webinars. And we would love to see our subscription numbers double before the end of the year. So if you want to help us out, go to our YouTube channel, subscribe, and take a look at all the videos that are posted there. We have over 50 videos posted. Leave a comment. Don't forget to share any of them with anybody that you think may benefit from the content. And if you want to be notified about when we do post a video, all you have to do is hit the bell button to be notified when videos are posted. Today's webinar, we're going to be talking about cases. We will be providing a list of the cases and their citations for CanLII so that you can access them at a later date if you want to read them for yourselves. We will post this list when we post the video. So the list will be posted in our YouTube description box or on our website where the video can also be found. During the webinar, if you have any questions, be sure to put them in the Q&A box. Don't put them in the chat box. We won't see them there. Make sure you put them in the Q&A box, and our panel is going to try their very best to get answers to your questions during the webinar. And again, don't forget, if you are a property manager and you're wanting to claim your CMRAO CPE credit for this webinar, put your name in the chat box along with your company name, and that will record your attendance. And then all you need to do is self-report it on your CMRAO account. And if this is your first time coming to one of our webinars, welcome. Let me tell you who CCI is. CCI is the Canadian Condominium Institute, and we are an independent nonprofit organization formed in 1982. We have chapters across the country, 8 in Ontario alone, and CCI Huronia is one of those Ontario chapters. Our main objective is education. However, we also advocate for condos, and we represent all those involved in condos, from owners to directors to professionals, and we encourage all these stakeholders to work together. So if you're not a member of CCI Huronia or a member of one of our CCI sister chapters, be sure to go to the national page, cci.ca. You can find a chapter near you, or if you want to become a member of CCI Huronia, and we would love to have you, you can go to our website, ccihuronia.com, and click on the membership tab. Also, if you are on the national website, be sure to check out the National Resource Center. There you can find a lot of material that relates to condo issues, and that material has been provided from our chapters across the country, so from coast to coast. Don't forget, CCI Haroni is also on Facebook, and we are on Instagram. And if you want to check out our newsletter, Condo Buzz, it's available on our website. And just a reminder to everyone that if you are a condo director and you want to use the protection of Section 37 of the Act, you do need to get an opinion about your specific fact situation from your own professional. This webinar is not intended to provide you with opinions that would protect you under Section 37 of the Act. In addition, the information provided in this webinar is current as of December 12th, 2025. So if you're watching this webinar at a later date, be sure to check with your professionals to make sure that the information is still relevant to your situation. And all references to the Condo Act or other legislation during this webinar is a reference to Ontario legislation. All right, so we've got a lot to talk about today, and we're going to get started with John Devellis, and he's going to give us some insight into 3 cases that were heard this year. We're going to be talking about odor and nuisance, shared facilities, and how far do your lien rights go. John, welcome to the webinar.
Thank you, Sonja. Welcome, everyone. Good to be here. My first case is Leduc and Ottawa Carleton Condominium Corporation 758. It's an application for an administrator. An administrator, what that is that under the Condominium Act, the court can appoint someone to essentially fill the role of the board of directors, replaces the board of directors and becomes the board of directors. It's something that is done as a last resort when the courts see that the corporation is dysfunctional or unable to govern. It is really a last resort, as I say, as we'll see, and very hard to get. So in this case, the applicants are 2 unit owners in a condo complex in Ottawa that is attached to a retirement facility. The retirement facility is called Villagia. The owner of the Villagia also owns 70 of 87 units in the condominium corporation. And that's where the tension lies, as we'll see in this case. The condo's board has 5 members, but there's 1 vacancy. And of the 4 remaining members, 2 are owner-occupied members, and the other 2 are generally elected, but essentially because Villagia owns 70 units, they are able to appoint those 2 members. And so there's a 2-2 deadlock on the board at the moment. The applicants argue that the board was dysfunctional and that the board ran the condominium as an offshoot of Villagia. And their main complaint was that a fee under the Shared Facilities Agreement, which is called the ACC fee, which is a fee to access the retirement facility, was charged only to the non-Villagia owners and not to the units owned by Villagia. Now, the court considered these arguments and rejected the application for an administrator. The reason was that although the board had not met for 10 months and had not held its 2024 AGM, the Profasis, Profasi was one of the applicants, and his wife is also one of the board members, so those 2 hold 2 of the 4 board positions. The court found that the Profasis were the reason the board was unable to meet and achieve quorum. The court found that it was disingenuous for the applicants to assert that a condominium administrator should be appointed, and it said, in effect, the Profasi has ground the work of the condominium to a halt in an attempt to get his way in a legal proceeding. And the court found that Profasi had acted in bad faith. Regarding the ACC fee, the court found that there was no evidence that the fee was prejudicial, that the way that the fee was charged was prejudicial to the non-Villagia owners, essentially because there was no evidence that the non-Villagia owners were subsidizing the Villagia owners. The complaint was the fact that they were charging themselves, and the court found that there was no prejudice to the non-Villagia owners. And the court emphasized that appointing an administrator is a last resort and a rare occurrence. In the end, the applicants were ordered to pay $78,000 in costs to the various partner respondents. And part of the problem with there is that there was so many respondents named that there was multiple lawyers involved. And so there was 2 sets of costs that the applicants were ordered to pay. The takeaway for this case is, as I said at the beginning, appointing an administrator is rare. And you really have to have your ducks in a row, and you really have to come to court with clean hands. The court will not sanction somebody creating the circumstances, in other words, creating the dysfunction that they are then going to point to and ask the court for relief. So that's that case. I'll move on to the next case then. The next case is Lee and Toronto Standard Condominium Corporation number 2205. It's a condominium tribunal case and is a nuisance claim. It also involves a consideration of legal costs. Um, although it's a nuisance claim, the owner who was accused of being the cause of the nuisance was actually the applicant. The condominium had written to the owner about it's a mixed-use condominium. The owner owns a commercial unit which is leased to an establishment called Burger Brothers. And about a year after the lease began, there was an odor complaints from a neighboring unit. There was about 11 verified complaints describing strong, greasy smells that occurred in the owner Lee's unit. The owner claimed that the cat at the tribunal that the condominium was wrong to accuse her of causing a nuisance, and also challenged the legal fees that had been charged back to her before the hearing started. The tribunal found that the odors were frequent and intense and enough to constitute a nuisance under Section 117(2)(b) of the Condominium Act. However, the odor issue ended when Burger Brothers left in March of 2025, and there had been no complaints reported after that. So while the tribunal ordered Lee to comply with the act and the declaration going forward, no further remedy was needed on the nuisance itself. Now, with respect to the legal fees, the Condominium Corporation had charged back about $4,000 in legal fees before the application commenced. And the owners challenged those legal fees. And the condo argued that the tribunal had no jurisdiction to reassess or retroactively order those fees to be repaid. And the tribunal found that it did have jurisdiction. And the reason was that the nuisance claims fell under the tribunal's jurisdiction, and therefore so did the related costs that were charged to the owner pursuant to the nuisance claims. The court also found that those legal fees were charged in bad faith and not warranted, and ordered the Condominium Corporation to repay the $4,000 to the owner. As well, during the proceeding, the Condominium Corporation wrote to the owner and wrote advising her that they were charging back an additional $7,000 in legal fees related to the CAT hearing itself. The court found that that was not allowed, that the jurisdiction to order costs rests with the tribunal, and the Condominium Corporation was not permitted to demand payment of legal fees while the hearing was in progress. And so as a result, the tribunal ordered that the $4,000 be refunded and that the demand for $7,000 in additional legal fees be retracted, essentially. The court also found the tribunal also ordered no cost in the proceeding itself because there was divided success. In other words, the condo got an order that the owner had been guilty of nuisance, but the owner was also successful in challenging costs. All right, last case for me is MTCC 1067 and the numbered corporation. Now, this is a good case to demonstrate why it's important to register your liens on time. What happened in this case is there was the corporate owner who fell into arrears of common expenses in 2021. And in 2024, the corporation registered a lien and also sued for vacant possession on the lien. The total arrears was $495,000. Of those, only about $111,000 were covered by the lien, because of course we all know you have to register your lien within 3 months of the arrears. So only the arrears covered. So for the 3-month period before the lien and following were covered by the lien. The court originally found that the entire arrears were covered by the lien on the basis of an oppression remedy. It was an ingenious argument by the Commonwealth lawyer, arguing that it was oppressive for the owner not to pay those costs because it was $400,000. The court agreed and found that they were all covered by the lien. The Court of Appeal did not agree, said that that was improper. The statutory lien period must be adhered to, and by allowing those additional fees to be covered by the lien, it prejudiced other encumbrances, other creditors of the owner. And so as a result, only $111,000 of the $495,000 in arrears were covered by the lien. The rest are the remaining judgment stands, but they're not covered by the lien, so they potentially lose priority over other encumbrances. So takeaway: you must register your lien on time. Those
Thanks,
are my
John.
cases. Happy to answer questions at the end. Thank you.
Thanks, John. And yeah, that's a good reminder that you can't contract out of the act. So So speaking of money, John ended on money. We're going to move over to Jake Fine now. And Jake, welcome to the webinar. This is your first time on one of our webinars. Nice to have you. And Jake's going to be talking about two cases, one about common expenses and claims against condos. So money is always a topic in condo land. And also about due diligence when you receive a request for accommodation. Jake?
Wonderful. Thank you very much, Sonia, and thank you for having me. So as Sonia mentioned, my first case today deals with a very common legal principle that, in condo land we deal with on a daily basis, but rarely do we see it in the courts. And so the first case is Numbered Company in Toronto Standard Condominium Corporation, number 2255. So the Condominium Corporation is a commercial plaza with 49 units, and the Numbered Company owns Unit 1. Now, this unit is unique because it's a standalone unit that occupies about 25% of the area of the corporation and pays about 25% of the common expenses. In 2019, the owner of Unit 1 decided that it wasn't going to pay its common expenses. And it had three reasons for this. So the first reason is that in 2019, there was a change in property management, and they said that since that change, they had not been receiving any notices, whether that be for meetings or otherwise. The second reason is because they claimed that certain parts of their unit constituted common elements, which required the corporation to maintain and repair, in which the owner had actually incurred costs to repair. And so they thought they required reimbursement for that. And the third reason was a very complicated issue related to the city's water charges for the entire complex, which may or may not have been charged to this unit who had paid them in full. So because of those three issues, the plaintiff said that they were exempt from paying common expenses. So as John mentioned, you have a 3-month period to register a lien in the event of arrears of common expenses. And so that's exactly what the Condominium Corporation did. And at the time of registering its lien, the arrears were approximately $20,000. 2 years later, in 2022, the Condominium Corporation issued a notice of sale. And at that time, the lien was approximately $475,000. And at the time of the hearing, which was in early 2025, this amount had risen to approximately $975,000. And that may seem quite large, but the reasoning, as I mentioned, is because this unit paid approximately 25% of the common expenses. So we have about 6 years of failure to pay common expenses, plus legal costs, plus arrears. So the issue before the court was really about whether or not it was going to strike some paragraphs from a claim that the Numbered Company had made, asking the court to deem that it was not required to pay common expenses. Now, the corporation said this was not allowed, and so it brought its motion to strike those claims. Now, in conducting its legal analysis on this matter, the judge found that there was a clear answer. And this is going to take us to the Condominium Act and specifically Section 84.3, which is the no avoidance provision. So Section 84.3 says an owner is not exempt from the obligation to contribute to the common expenses, even if the owner is making a claim against the corporation. So again, in this case, the owner said that because of those three reasons that I listed at the outset, and because it had brought this claim, it does not have to pay common expenses. Now, the judge made two very good quotes as to the reasons why this was such a complete answer to this case. I'm going to read them for you. So the judge said that there are good public policy reasons for a simple, direct, and unqualified application of this provision. If it were otherwise, it would be far too easy for unit holders to avoid common expense payments by taking the position that the corporation was somehow in default of or fell short of some obligation to the unit holder. That would unnecessarily complicate the efficient management of condominium corporations. And in addition, he said that under the policy reflected in Section 84.3 of the Condominium Act, the corporation's obligation to provide services and the plaintiff's obligation to pay common expenses are two separate and distinct matters. If the plaintiff believes the corporation is not providing services, it must either engage with the corporation to have those services provided or pursue the corporation through the courts and not resort to unilateral self-help by failing to pay common expenses. And in this case, the corporation was severely underfunded because 25% of those common expenses were not being paid over such a long period of time. And ultimately, those costs had to be sought from the other unit owners. So the main takeaway from this case, which I stated at the beginning, is a very common principle, but one that we don't see often, is that there is no avoidance to paying your common expenses. So my second case today deals with Waterloo North Condominium Corporation number 37 in Baja. And I do have to admit, I cheated a little bit on this case. We were asked for 2025 cases. This was appealed in 2025. However, the underlying case, which I do want to talk about, is a 2024 case. But I think that it's very important given the decision on appeal. So in this case, Miss Baja and Mr. Murphy reside in a unit, and they both have dogs. Now, the president of the corporation, who resides under Miss Baja, made complaints regarding dogs, and specifically barking. The corporation had a one-dog policy per unit, and obviously this unit had two dogs. Now, in response to this, Miss Baja says that both Miss Baja's dog and Mr. Murphy's dogs are required for accommodation purposes. So, as a condominium corporation does when there's a request for accommodation, it asks for medical evidence. And so Mr. Murphy went out, got a letter, and provided to the corporation. But unfortunately, the corporation didn't accept it. It asked for more information. So Mr. Murphy went out, got a second letter, and provided it to the corporation. Now, what made this letter unique was that Mr. Murphy's treating physician said that his service dog was a necessary accommodation. Now, unfortunately, the condominium corporation did not accept this letter either, and specifically because it did not indicate the medical need of this dog rather than the preference of the animal. So in other words, the corporation was seeking to see whether or not another dog or another animal or another type of accommodation would be sufficient to assist in Mr. Murphy's accommodation needs. Now, ultimately, when this was before the Condominium Authority Tribunal, the CAT held these things. Number one, that the corporation didn't establish that the noise from the dog was unreasonable, that the condominium corporation was not entitled to demand details regarding Mr. Murphy's disability-related needs, that it was not appropriate for the corporation to disregard the opinion of a doctor, as the doctors clearly indicated that the dog was a necessary accommodation. And then on top of that, the CAT made an order for $15,000 in damages in favor of Ms. Baja. Now, as I mentioned, in 2025, this case was appealed by the Condominium Corporation, but it was ultimately dismissed. So what are the takeaways from this case? Accommodation is a big issue that we're seeing in our law firm, and it's coming up a lot. And I think that it's really important that corporations conduct their due diligence when they receive a request for accommodation, but they have to be more flexible in its approach. Now, we look at the difference between medical need and preference, and we do see that there is case law which would otherwise permit the corporation to ask those questions. One case before the courts, Dominelli. There's other cases before the CAT, which state that, for example, that while a resident was required or did determine that a accommodation of a dog was required, the corporation could set a limit on the weight of the dog. Now, in this case, what makes it unique is that Mr. Murphy's physicians clearly identified that this dog was necessary. And unfortunately for the condominium corporation, it got entrenched in its position, which led it to this end where, unfortunately, they continued to demand that Mr. Murphy remove his dog. And ultimately, as we saw on appeal, that was not upheld. And then the second is that the CAT has jurisdiction to award damages for discriminatory treatment by a condominium corporation. And again, because in this case, the CAT found that Ms. Baja and Mr. Murphy suffered discriminatory treatment, injury to their dignity, feelings, and self-respect, and had to leave their home, the court awarded damages. So again, when we look at accommodation cases, we have to be flexible as opposed to a rigid application, as we would with, let's say, the Condominium Corporation's declaration, bylaws, and rules. And we we have to be flexible because, again, the CAT can award damages for discriminatory treatment.
Thanks, Jake. And having been the one who argued Dominelli, I find it so disheartening that the CAT doesn't recognize what the court said in that case, and the ability of the condo corporation to ask appropriate questions. But that the case that you spoke about, the Baja case, it's just a really good reminder that condo corporations, when they're dealing with human rights requests for accommodation, it is a very tricky process to maneuver, and make sure you get some legal advice on how to deal with it right at the very beginning, because don't forget, you've got procedural obligations as well as substantive. So thank you, Jake, for that. And now we're going to move on to Patricia Elia, who is no stranger to these webinars. Patricia, great to have you again. And Patricia is going to be talking about two cases, one dealing with parking rules and chargebacks. Chargeback seems to be a good theme today, as well as powers of attorney and harassing behavior against not only the corporation, but the owner itself. So, Patricia?
Thanks very much, Sonja. And I love Dominelli. I still put it out there, and I think it's important that we establish the needs. But enough about that. I'll talk about visitor parking. This shows the breadth of what we do in condominium law. So this case is involving Belinda Marizzato, the applicant, who was challenging the validity enforcement of visitor parking provisions in the governing documents of WCECC number 519, a common element condo. Now, initially, the corporation didn't participate in the case due to an oversight at the CAT level, but then was allowed to join in. And the tribunal found that the visitor parking provisions of the corporation's governing documents were valid and enforceable. However, that several charges against Marizzato for alleged violations were deemed invalid. So in terms of the background, this corporation had a visitor parking rule. They added a new rule on August 8th, 2022, a pivotal date for decision making in this decision, which is Rule 12, which specified in quite a lot of detail, including specifying the process in which visitor parking rules will be enforced. And this rule came into effect then. And the CAT had to address four very specific topics: the validity of the visitor parking provisions, and the tribunal confirmed that the visitor parking provisions and their reasonable enforcement was fine and it was upheld. But there was a caveat that enforcement activities must be confined to their property. Okay, and that makes sense. Corporations should operate within their boundaries. One of the interesting things about the rule provided literally in the rule, the letter process for violations of these visitor parking rules will conclude at 2 compliance letters. If the resident continues to violate the corporation's rules, stronger actions will be taken, which may include ticketing and towing and/or legal enforcement via the corporation's solicitor at the sole expense of the vehicle. Now, I really like sort of the comprehensiveness of what they're trying to do here, which is full out telling you what's going to happen. What I question is whether this is actually part of a rule or whether this is about process and policy, because that's one of the key things talked about in this case. And what happened is, unfortunately, the corporation didn't adhere to its own rule and the embedded policy structure. And that's where the chargebacks that were charged were found to be and found not to be valid were thrown out. And one of the interesting things is that the case reiterates from the tribunal's perspective that a condominium cannot alter its rules by making policies. If a board wishes to change its rules, it must do so in a manner set out in Section 58. So this is the Zolas case that is being quoted, and that makes sense. If you're going to have such specificity in your rule, and then you're going to change the process, because the board here went from 2 letters to 1. So you need to provide fair and clear and transparent, both warning and transparency on the process. So then the tribunal, though, went on to talk about chargebacks and enforceability. But before I get there, there was one other point I wanted to bring up is that the CAT did a very interesting thing. It actually analyzed the notices. And one of the things that they held against them was the content of the notice. The notices were found to be inconsistent in their content. And at first, I was sort of taken aback that somebody's actually looking to analyze every specific thing. But if this is where we are now, there were some pointers here in that it said the notices contained no timeline or duration when a vehicle associated with the unit would be deemed to cease being that of a visitor. So there was no clarity on when you stopped being a visitor in one part of the rule. But also, they said that it didn't have enough specificity to align it back to the rule. Whereas, what I found interesting is if there's a notice violation going out, what you should be doing is making sure that you're quoting the rule and really talking. If you're going to specify process, you would say, this is the second letter out of the two that we prescribe under the rule so that there's clarity. There was a quote in there that talks about Emlani, and it says, I also note that the courts, referencing Emlani and this tribunal, have consistently determined that condominium corporations must not seek to collect or enforce collection by way of lien provision under the Act without obtaining a prior court or tribunal order. I disagree with that statement because I don't think that's what Emlani stands for. Emlani actually talked about the indemnity in the declaration and whether the indemnity gave you the ability to actually collect those amounts as a chargeback. That's something that you've got to go to your lawyer about and really read that declaration, indemnity, to see if it allows for a chargeback. You are allowed in your declaration to have language that allows the corporation to collect back items that are chargeable back to the unit. So that could be for compliance enforcement costs, but you have to have the right indemnity. So that, and then on the harassment claims, there was no claim of harassment because here the tribunal found those nature of those claims and the language used put it into a 117.1 claim, and it was outside the tribunal's jurisdiction. And so costs were granted in favor of Marazzato, but also there was a refund of some of the chargebacks. I'm going to move to another case, YRCC 570 in Ettery, which is a compliance application under 134. And in these days, we live in multi-generational living in condominiums, and we have something called aging in place that happens quite often. And the application was to prevent Renee Ettery from occupying or visiting a unit at YRCC 570 owned by her mother, Catherine Ettery, as a result of her dangerous conduct. The facts of the case were that Catherine had purchased the unit and lived there without issue since 2020 until 2023. Her daughter Renee moved in with her when she returned from Israel working abroad, and she decided to take care of her mother, and she lived there as a resident, not as an owner. For some time, Catherine had suffered from Alzheimer's and was deemed by her physician incapable of managing her property and personal care. In July, though, 2023, Renee, prior to moving to the unit, Catherine had appointed her other daughters, Esther and Joyce, as her powers of attorney for the property and personal care. So Renee didn't have power of attorney. Almost immediately after Renee moved into the unit, her presence resulted in significant disruption to those around her. The corporation alleged that Renee had engaged in a campaign of harassment and intimidation towards the property management. Specifically, the corporation adduced evidence on multiple occasions that Renee had photographed her and harassed the property manager, which was all true, and as well that her actions contravened the OHSA. So ultimately, in the hearing before Justice Fraser tried to get the PGT, the public guardian, involved and to address these concerns. The public guardian declined, but then Renee produced a power of attorney that was signed months after the original one when her mother was not ill. The judge did not take that as being binding authority on the court. because there was a question then about abuse of authority. So ultimately, the court concluded that many people have attempted to resolve this situation resorting to court. However, it has been without success. I conclude that Wire CC 570 has demonstrated non-compliance and that Catherine and Renee are in breach of 116, 117, and 119 of the Act and governing documents of 570. The court did say, I do not fault Catherine for the current situation. In my view, she does not have the ability to exert control over Renee. The remedy for Renee is to leave the unit and for her to be prevented from visiting her mother at the condominium, except with the express consent of 570. So this decision underscores the growing intersection of condominium law, elder care, and mental health. Condominium boards are increasingly being called upon to address challenging interpersonal situations that extend beyond true violation. This case confirms the vital role that boards and property managers play, not in just enforcing the rules, but in protecting vulnerable residents and ensuring a safe environment for employees and neighbors alike. But as a denouement, I will say this, that Mrs. Edery had to sell her unit. And as she went to live with this daughter, and there is an ongoing discussion about this care of this individual, we should not let it get to the point where people are losing their units. I think that earlier intervention by a third party like the PGT might be helpful. And I think we may need to see legislative change to afford that. Thanks very much, Sonja.
Thanks, Patricia. And that raises a whole bunch of questions that if we have some time today, we can get into about the condo's duty to intervene, in inter-unit issues versus condo versus unit issues. Yeah.
Yep.
Thanks, Patricia. And now we have Ashley Winberg with us, who is also one of the board members of CCI Haroni, has been on our webinars before. Ashley's going to talk about two cases. She's going to talk about nuisance and noise and harassment. Ashley.
All right. Hi, everyone. Thanks for joining us today. The first case that I'm going to talk about is Rock vs. Man in Low, and it's a CAT decision from the Condominium Authority Tribunal that was released in May of this year. So this case involved a dispute between two units regarding noise transmission. The applicant occupied the unit below, and the respondents were the owner and occupants of the unit above. So the main issue was whether the occupants of the unit above, which was a family of 5 with young children, whether they produced noise that was unreasonable and resulted in a nuisance, annoyance, or disruption to the applicant who was the occupant of the unit below, which was a violation of Section 117. So it was whether or not it was unreasonable noise. So this was the second application that this applicant had brought. She'd brought a previous application, but this particular application focused primarily on whether or not the level of noise was unreasonable, and in this essentially the applicant was disappointed with the results of the prior application that she had filed, how it was resolved. So the CAT held that the noise that the individual was complaining of was consistent with the activities of normal daily living of the occupants of the unit above their lives, which included 3 young children and 2 adults. So there was footsteps and there was running and there was objects falling and sometimes children yelling. That is the normal activities of a family with young children. CAT found that the occupant of the unit above did take steps to reduce the amount of noise, which included purchasing carpets and mats and encouraging his children to try and reduce their noisy activities. The corporation, the condominium manager, also indicated that there was indeed carpeting that had some sort of foam backing in the unit, and that it covered most of the kitchen and dining room, which was really where the family lived and would have been producing the most noise. The applicant, the occupant of the unit below, had purchased a sort of sound measuring device, which she thought measured noises that were between the range of 40 to 60 decibels. However, she wasn't able to corroborate this evidence with any sort of recordings, and she really didn't do a great job at logging and journaling the reported noise. So the evidence that she presented was really her own testimony. And the corporation was an intervener, and they provided evidence that the building staff had investigated the complaints and they had never confirmed that there was any unreasonable noise coming from the unit above the applicant. So the tribunal found that in order to find unreasonable noise requires evidence that confirms that the noise, the type of noise, the frequency is objectively unreasonable. And although the applicant, measured levels between 40 and 60 decibels, this does not establish that the noise was unreasonable. In fact, 60 decibels can be consistent with what normal conversation is recorded as. And it's particularly conversation within a household of 5 people. And the CAT also held that when there are no defects in construction, which was ruled out by an acoustical study that was done, noise that is produced from a multi-residential, within a multi-residential building, particularly this family, was not considered unreasonable, particularly in absence of supporting documentation confirming the nature, frequency, and intensity of the noise. And for those reasons, CAT found that the applicant did not establish that she experienced unreasonable noise, and her application was dismissed. Now, there are some key takeaways from this case, and I have been referring to this case quite frequently, since this is something that does arise very often in high-rise buildings. So objective evidence matters. That is key number 1. Although someone's personal account of sleepless nights and emotional distress is part of a valid noise complaint, it is not objective. Expert evidence needs to establish that the level of noise, the frequency, the type, duration, it is objectively unreasonable. Also, the second takeaway, which is one that's repeated in a number of cases, is that in multi-residential buildings, residents do not have a right to absolute silence. A right to quiet enjoyment does not mean a right to absolute silence. And it's, hearing the noises from other people that you're living with, that is part of living in a multi-residential community. And a certain amount of noise has to be accepted and tolerated. And third, my takeaway I refer to quite frequently from this case is condominium corporations will also often state that the building was constructed in accordance with the minimum sound transmission requirements of the Ontario Building Code. So there are no construction defects. And that may be true. However, the Ontario Building Code has there's limits on its acoustical requirements. And in particular, it was recently updated in 2020 to include ratings for flanking noise, which is noise that travels through construction points like floors and ceilings. However, there's still kind of a gap in the Ontario Building Code with respect to structure-borne noise, which is noise that when people complain about vibration sometimes, so noise that's traveling through the building's physical structure. So essentially, a condominium can claim that, yes, the building was made to code. This doesn't necessarily invalidate a resident's complaint about structure-borne noise, because that is largely unaddressed in the code. And mitigation in this particular case as well helped. The occupant of the unit above was, very compliant and helpful. They installed carpets and mats. They tried to do what they could to address the individual's complaints as reasonably as possible. And that is something that the CAT will take into account. My next case I'm going to discuss is Peel Condominium Corporation 96 versus Carmine Lucy, and it was a case that was released in June of this year. And this case was heard by the Ontario Superior Court of Justice, and it involved two applications. So the first was an application bought by the Condominium Corporation seeking a compliance order under Section 134 of the Act against the unit owner to compel him to cease his harassing conduct, alleged harassing conduct. The second was a cross application brought by the owner who claimed or wanted an oppression remedy under Section 135 of the Act. Ultimately, the court granted the condominium application and dismissed the owner's cross application. So the corporation, the main issue was whether or not the owner's conduct constituted, injury or illness that is prohibited under, whether the owner's conduct constituted a nuisance or workplace harassment, and whether the conduct was likely to cause injury or illness to others, which is prohibited under Section 117 of the Condominium Act. The court found that the owner had engaged in a course of vexatious conduct that did breach Section 117 of the Act, which the court concluded does prohibit activities that are likely to produce psychological harm or abuse. The owner's initial complaint, this all originally originated from the owner complaining about a neighboring occupant smoking on their balcony. The corporation investigated and looked into the complaint, and then also sent a cease and desist letter to the owner at issue because he was pouring like some sort of a vinegar mixture down onto the smoking person's balcony below and using a threatening tone toward a board member and making racist remarks. The corporation then, over a period of 10 months, received at least 119 emails from this individual that was sent to the corporation's managers and agents. And in the emails, he frequently demanded immediate answers, and he threatened to make complaints to regulators like the CMRAO and the Law Society. And the court found that the volume of this correspondence far exceeded what the corporation could reasonably handle. And his threats to, make complaints to various regulators could amount to harassment. Critically, the court held that the individual was engaging in bullying, which kind of the court called "quote unquote" keyboard bullying, in which he was making derogatory comments and unfounded complaints, which was amounted to workplace harassment. And under the OHSA, condominium corporations have a duty to investigate and address any incidents of workplace harassment. One of the most serious allegations that the individual made against property management was that he claimed that they were engaging in financial impropriety. And this actually led to the corporation having to undergo an expensive audit that cost nearly $40,000. And there was, no evidence of impropriety that was found. The owner also, the court found, deliberately hijacked a town hall meeting by loudly disrupting the chair, screaming at directors, and ultimately the chair had to force the meeting to come to an end. So the court concluded that yes, the individual did engage in a course of conduct that was aimed at discrediting and harassing the corporation's board, management, and staff. The court held that the corporation was indeed entitled to the compliance order that they were requesting, because the corporation doesn't have to sit in silence. It has to ensure that any communication that owners engage in are done in a civil and a lawful manner. And the corporation ultimately has a statutory obligation to address any potential incidents of workplace harassment, which this individual was engaging in.
All right. Thanks, Ashley.
Pardon me?
Thanks.
Oh, okay. Sorry. I have a couple takeaways, but if we have time, I'll get to them.
Okay. Yeah, we have some time. We can, if people have questions, they can put it in the Q&A box. And we've got about 10 minutes left. And I'm going to talk about the same case Ashley was talking about, PCC 96 and Lazuzzi, but from a different perspective. Because one of the interesting things that I found out about that case when reading it was the comments about the admission of evidence of recorded meetings. So in that case, Ashley's given sort of the background of the facts there, but in that case, Mr. Lazuzzi recorded a town hall meeting that took place in October 23. And then there was also a recording between a meeting that was held between a board member and some other residents or owners, of which Mr. Lazuzzi was not present at that meeting. And he was trying to introduce these recordings into evidence in the court proceedings. And the condo objected to the introduction of that evidence. And there's a rule of evidence when we deal with court proceedings that says that hearsay evidence, which is any out-of-court statement that is being offered to prove the facts, the truth of what it's asserting, is not admissible unless it falls under one of the exceptions. And usually it's not found to be admissible because it's unreliable, it's not made under oath, it's not subject to cross-examination, and there's a real risk that the recording could distort the truth-seeking process. So in this case, what the court actually held with respect to the recordings is that they said that the recording of the town hall meeting could be entered as narrative evidence, and that's evidence that's really admitted for the purposes of understanding how things happened, not for the truth of its contents. And so they allowed it for the purposes of narrative evidence. And they said that the owner, Mr. Lazuzzi, he had attended the meeting, he had made the recording, and the court found it helpful to understand how the meeting unfolded and the proper context, and to be able to assess the credibility and reliability of witnesses in the court proceedings, including Mr. Lazuzzi himself. But you've got to be careful what you ask for, because although Mr. Lazuzzi was asking for this recording to be admitted and the condo was objecting to it, the court admitted it, but they actually used it against Mr. Lazuzzi in their decision because they referred to what happened at that meeting and Mr. Lazuzzi's behavior during that meeting, and basically found that he had hijacked that owner's town hall. Also, they allowed the town hall recording as admissible evidence on the basis of a party's admissions exception to the hearsay rule. And this is a rule that allows a party to litigation to seek admission of any statement made by the opposing party for the truth of its contents. But again, the court allowed this to be admitted, but then used it against Mr. Lazuzzi at the end of the day. So the other recording, which was a meeting between the board member and other residents, was found to be not admissible. The court's comments in relation to that recording said that there was firsthand evidence was available from these witnesses, so that would be more reliable than having this recording. And a reluctance to testify was not a good enough excuse to rely on the recording as opposed to subpoenaing the witnesses. Also, the court raised concerns about the fact that the recording was condensed from its original version, and they were concerned that there was parts missing that would impact its reliability. So a couple of good things to take away from this. Just like we always say, whatever you put in a document, when you write a letter to someone, always think about it from the perspective that that letter may end up in front of a judge. So think about what you're putting in that letter. Think about the tone of that letter. The same thing applies to any kind of encounters, whether it's meetings online or meetings in person. I think you need to always keep in mind that somebody may be recording that. And so think about what you're saying, how you're saying things, and make sure that you're following procedures properly so that if it does end up in front of a judge, you're not going to be embarrassed. The other thing to remember is that if you are going to emit a recording or try to emit a recording into evidence, make sure you're not altering that recording. Otherwise, any value of that recording is going to be diminished. And just a reminder that under the criminal code, you are not allowed to record conversations that you are not a party to. So if you're not part of the conversation, you can't record it. That's actually a criminal code violation. So the other case I wanted to talk about is actually not a condo case, but I think the lesson from this case is really important. And it's a case that started at the Human Rights Tribunal. It's called Doso versus the HRTO. And the interesting thing about this case is what happened is the HRTO made a decision, and the parties, one of the parties sought judicial review of that decision. And the matter came before the Superior Court for an application for some parties to intervene, to be interveners and to be added to the judicial review as an intervener. And this type of application is heard in writing. But the funny thing, and it's not so funny, I guess, if you were the parties, but it is definitely a good lesson for all of us to remember. That same application that was filed was sent to two different judges, and two different judges rendered a decision, and they got two different results. And both decisions were released one day apart. One judge allowed the application to intervene. The other judge didn't allow the application to intervene. And it's interesting if you read the two decisions and what the judges had to say in their decisions. Both of judges focused on totally different things. And they took a look at the same issue, the same requests, from different perspectives. And it's a good reminder for everyone out there to just remember that when you go to court or to CAT or to an arbitrator, anyone who is going to be making a decision, you never are guaranteed what the result is going to be, because everyone who is making a decision, they're humans, they're coming to that position with their own experiences and background and training, and they're looking at your case from those lenses. And so it's really important to remember that the result of any decision will be basically resting on the decision maker. So whoever you get that day, and that's something we can't control, whoever you get that day, that's what you're going to be faced with. And so litigation, in whatever form it takes, there are no guarantees. Judges, adjudicators, arbitrators are human, and they're going to look at things from different perspectives. So it's really important that when you're presenting your cases, that you take a good look at how someone else may see your case, and not assume just because you think you have the best evidence or you think the law's on your side that you're going to win. Always take a look at it from a different perspective and make sure that you're addressing concerns that someone else may have if they were to look at the same facts. So interesting case. At the end of the day, the court basically quashed both decisions and then rendered a new decision allowing the interveners to be added. But that new decision was basically on consent of all the parties. So it's a bit of an embarrassment for the courts that we have one case, two different decisions. But it is a good lesson for everyone to remember that, it doesn't matter how good you think your case is, you're never guaranteed that you're going to get the result that you want, because adjudicators, they may see it from a different perspective. So that wraps up our webinar for today. And I want to thank all of our speakers for joining us. Thank you for sharing your thoughts. We didn't have a chance to get to the questions. Some of the questions we did answer in the Q&A, but we'll have to save those questions for another webinar. And just a reminder to everyone that this wraps up CCI Haronia's Lunch and Learn webinars for 2025. But we have a great lineup planned for next year. The topics and speakers have not been released yet, but our dates have been released. So if you want to write these dates down and put them into your calendars, our Lunch and Learn webinars, which go from 12 to 1 on Fridays, the dates for 2026, the first 6 months, will be February 20th, March 20th, April 17th, and May 22nd. Also, we will be doing our Intro to Condo course on January 28th from 6:30 to 8:30, which will be an online course that is free. As always, our webinars are free of charge, thanks to our sponsors. And we will be doing 2 director certificate course programs on March 11th and April 22nd from 6:30 to 8. We'll be doing the 101 Governance Fundamentals course as well as the 105 Reserve Fund Fundamentals. And stay tuned, we are planning an in-person event in June. And once we get plans finalized, we will be posting those on our website. So always check out our website, cciharmonia.com, for more information about all of our events. And before I go any further, I do want to take one last opportunity today to thank our sponsors. And without the support of our sponsors, we're not able to present these webinars free of charge. So thank you to our sponsors, Elia Associates, Condominium Lawyers, Pretium Consulting Engineers, Common Ground, Condo Law, and Engineering Link. And before we wrap things up for today, I just want to remind you that some of our sister chapters around Ontario also have events scheduled in the new year. You can always go to the cci.ca, which is our national website, to look at all the upcoming events at all of our chapters across the country. But here's a reminder of some of the events that are happening. CCI Golden Horseshoe on January 15th will be doing a webinar, Life of a Condo from Infant to Toddler. That'll be from 7 to 9 p.m. On January 27th, they have Money Matters, Making Sense of Condo Audits. Our friends in London our friends in Ottawa on have events coming up, which you can find out about on their website, CCI Eastern Ontario, as well as our friends in London will be posting their events on their website, ccisouthwesternontario.ca. Our friends in Grand River are running the Director Certificate Program throughout January, January 7th, 14th, 21st, and 28th. They're doing 101, 102, 103, and 104. You can go to their website, cci-grc.ca, for more information about that. And our friends in Windsor are doing a legal roundtable on January 29th. Go to their website, cci-windsor.ca. Don't forget, if you've missed any of our webinars throughout this year, they are recorded. They're on our YouTube channel as well as on our website. If you have any ideas for upcoming webinars in terms of topic matters or speakers, please send an email to admin@cciharmonia.com. Let us know what you would like us to talk about. Also, if you're not on our email list, but you wish to be, you can send an email to admin@cciharmonia.com and ask to be put on our email list. And that way you'll be up to date on all the events that are happening in our chapter. So that's a wrap for this year. I'm Sonja Hodis from the entire CCI family to yours, wishing you a happy holiday season in whatever manner you celebrate. All the best for 2026, and we hope to see you back here in February when we start our new season of CCI Huronia Lunch and Learn webinars. We will have a great list of topics and speakers available, as well as an opportunity to get your questions answered. So happy Friday, everyone. Don't forget, CCI is your condo connection, and we'll see you in February.